distracts from these concerns. Thank you.
Thank you for that, thank you for stepping in when the author of the article on Fisher in our volume, Peter Kirsanow, a member of the U.S. Civil Rights Commission, was unable to make it to present it. Next, we have my good friend and sometime co-author, Josh Blackman, apparently standing right behind me, who is an associate professor at the Houston College of Law and an adjunct scholar at Cato. He is the author of the critically acclaimed Unprecedented, the Constitutional Challenge to Obamacare, and the imminently forthcoming Unraveled, Obamacare, Religious Liberty, and Executive Power. Come back for the book forum on that in 2 weeks. Josh has also authored over 24 law review articles, and his commentary has appeared in all the major national publications. Perhaps most importantly, Josh is the founder of Fantasy SCOTUS, the premier Supreme Court fantasy league. Josh will be channeling Justice Scalia as he discusses President Obama's executive actions on immigration in United States versus Texas, and I will be nominating his essay in that regard, faux opinion, as it were, for the Green Bags Exemplary Writing Award. So any of you who have votes in that category, please second that.
Competition's rigged. It's rigged. It's a special treat to be here. My first time at the Cato Institute was in 2007 when Ilya had his first gig as the editor-in-chief of the Supreme Court Review. It was his first day, and it's somewhat surreal to think that, you know, less than a decade later, I was sitting where you're sitting, and now I'm up here. So for all the young people in the room, there is hope, and if you work hard, there is rewards, even in this city. It's true, even here. My talk today is on a bizarre case, United States versus Texas. As I'm sure you all know, this was the challenge to the president's executive action on immigration. Now you're saying, wait a minute, Josh, how are you here talking about the case? There was no decision. The entire decision was 8 words. The decision's affirmed by an equally divided court. So what I tried to do was imagine, you know, John Lennon, right? Imagine what could have been had Justice Scalia been here. When the case was granted, there were 5 justices, I think, who would have invalidated the program. By the time it was decided, there were only 4 left. So on page 79 of your book, what you'll find is actually a mock opinion that I drafted in my best Scalia voice, although I cannot do justice to his tone, of how this case could be resolved. This case, more than any other, I think represents a perfect storm of unconstitutional executive action. It represents a very dangerous pattern. The president wants a bill to be passed. Congress says no. Then the president takes an action that looks very much like the statute Congress rejected. This is a case where myself and Ilya agree with underlying policy. That is, we agree with the president's immigration bills. Where we part company is on the legality. And in fact, I'd like to praise Cato, because Cato simultaneously argues that this is good policy, but bad law. And I don't know many think tanks would actually be willing to entertain that diversity of thought. So let's take a step back and begin with the DREAM Act, okay? What is the DREAM Act? This was a bill that would have given a pathway to citizenship for the dreamers, certain minors who came to the country without status and then stayed on, graduated from high school, graduated from college, were upstanding people. The DREAM Act was a good bill, in my opinion. It would have given them a pathway to citizenship. These people were here through no fault of their own. The DREAM Act passed the Democrat-controlled House of Representatives, but it was filibustered in the Senate. And people forget, but there were several Democrats who joined that filibuster. At the time, the Democrats had 60 votes in the Senate. So what happened? About a year after the DREAM Act failed in Congress, President Obama announced the first of his executive actions in immigration, known as DACA, D-A-C-A, and the acronyms matter, so please bear with me. DACA was Deferred Action for Childhood Arrivals. What this bill, I call it a bill. What this policy did was to put on hold the deportation of roughly 1.5 million dreamers through a practice known as deferred action. What is deferred action? Basically, it means we will not put you at the top of the list of prioritization for removal, right? You're not here legally, you have no status, but unless you do something really stupid or we change our minds, we're not going to remove you. That wasn't the biggest problem here. The biggest problem was this policy granted something known as lawful presence. Now, what is lawful presence? It doesn't mean you're illegally, but it does allow you to receive a host of benefits that are basically authorized by the Attorney General and now the Homeland Security Department. The key benefit therein is work authorization. So you're not here illegally, but you can work, you can earn a free living, you have to pay taxes, you get Social Security, and a host of other benefits. All right? What happened after DACA was enacted? There frankly wasn't much outrage, and this is somewhat surprising, but the only people who filed suit were people like Joe Arpaio and others. There wasn't much serious litigation that followed the DACA suit. So in my mind, Congress perhaps acquiesced to that wrongly in my mind. Fast forward a couple years, the so-called Gang of Eight bill, right? This was Marco Rubio's bête noire, right? This is what took him down. The so-called comprehensive immigration bill that was given a pathway to citizenship for, 11 million aliens who are not here legally. The bill, in that case, managed to pass the Senate due to the Gang of Eight compromise. However, it went to the House. The House had, in fact, a majority of votes to back it. But due to the untimely defeat of Eric Cantor in his primary by a guy named Bratt, Speaker Boehner said, you know what? I'm not bringing this bill up for a vote. This will kill my members to have this vote take place. So the Gang of Eight bill never even came up for a vote in the House of Representatives. Later that day, in the Rose Garden, President Obama appeared, and he said, I'm paraphrasing, if Congress will not act, I will. Where Congress will not take action, I will act. Okay. So what happened after that? Throughout the summer of 2014, the Homeland Security Department gave the president nearly 60 iterations of an immigration policy to go further and further. And every time DHS gave him a policy, Obama said, no, doesn't go far enough. Keep going, keep going. He was disappointed. When his lawyer said, Mr. President, this is what we can do, no, go further. Finally, on November 14th of 2014, about a week and a half after the midterm elections, the president appeared in the White House for a speech. Not a balcony, but at least in the grand hallway, where he announced a new policy known as DAPA. There was DACA, now there's DAPA. DAPA stands for Deferred Action for Parents of Americans and Lawful Permanent Residents, a mouthful indeed. DAPA would have granted deferred action status to roughly 4 to 5 million aliens who had U.S. citizen children. To disabuse the anchor baby myth, if you come to the United States and you have a child, your child is in fact a citizen. However, the parent does not get citizenship right away. The child must turn 21 before they can petition for a change of status. Obama said, no, that's not fair. So if you come here and have a child who's a U.S. citizen and you're not a criminal, whatever, we will give you deferred action and we will defer your deportation. And oh, by the way, give you work authorization so you can come out of the shadows, right? You come out of the shadows, this beautiful image of lightness. Shortly after, I think maybe 2 weeks after DAPA was announced, Texas, joined by eventually 26 other states, filed a lawsuit. And I should note, kudos to Ilya and my good friend Roger. Cato was one of the first groups to file an amicus brief in the district court. It's very rare that Cato actually does a brief in the district court. But we realized very early on this case was big and head to great paces. We wrote that brief in maybe 72 hours. It was a quickie, but I thought very significant. Texas asserted a number of claims. They asserted that this was a policy that needed to go through notice and comment rulemaking. They asserted that this was contrary to law. But they also raised a third issue, an issue which is the subject of my piece for the review, the Take Care Clause. Now, how many of you studied the Take Care Clause in law school? Okay, other than the other Ilya, that'd be Ilya Soman, no one raised their hand. The Constitution imposes on the president a duty to take care that the laws are faithfully executed. Historically, this has been a power-granting provision. For example, the president says, listen, I have to faithfully execute the laws. That means I can fire whomever I want who cannot serve my cabinet, right? These are the removal power cases. We have a different situation here. The problem is not one of an energetic executive, to quote Hamilton, but a passive one, to quote Justice Scalia in my mock opinion. The problem here is that the president is not enforcing laws. Or more specifically, he decides to use discretion when it's really a decision to not enforce laws he doesn't like. So the briefs we argued for Cato in the district court, in the circuit court, and SCOTUS made this point in increasingly good ways. If we study the original understanding of the take care clause, the basis was one of good faith. We've all studied contract law. When you have two parties negotiating, there's an expectation that one party will fulfill the contract according to the other party's expectations. So when Congress passes a certain law, they have an expectation how it will be enforced. Now, to be very clear, we are not saying that the president has to enforce immigration law 100%. That would be impossible and probably unethical to instantly remove 14 million people. There's not enough money to do that in the world. I don't care how high the wall is, how high it goes, how deep it goes under. We are not getting rid of these people. It's impossible. There is only enough money to remove 400,000 people a year. But once you get past that straw man, this is the straw man that everyone raises. Once you get past that, okay, now we have to cut down to brass taxes. Is the policy the president acting actually a way to conserve resources, or is he trying to bypass Congress that won't change the laws? And I think the facts show overwhelmingly, by the president's own words and deeds, that he is trying to subvert a law that Congress will not use. When his lawyers told him, here are the limits of your power, he said, no, keep going, guys, keep going, go further. This is an instance where the president does not like the law and simply decides to pretend he's using discretion to get around it. This, as we've argued in our briefs, violates the take care clause of the Constitution. Now, had this pan out in the actual litigation, now, because the district court judge only ruled on what's called procedural rules, right, had to go through notice and comment, and the Court of Appeals only ruled on substantive grounds, no court has ever addressed the constitutional issues. Although there was one question raised during the oral arguments that evoked Justice Jackson's decision in the Steele seizure case, which is a personal favorite of mine. And you may recall that Justice Jackson wrote that we have to see, is Congress and the president lining up? Okay? If the president is doing something exactly at odds with Congress, that's a good sign for us that this action is illegal. As we argued in our brief at some length, we are in the lowest ebb of Jackson's framework. It's undisputable how low we are. Think about the chronology. President asked, I want you to change this law. Congress said, no. He said, okay, I don't care, I'm going to do it anyway. I'm going to take action that are very similar and benefit the exact sorts of people who Congress would have changed the status quo for. If that weren't enough, afterwards, Congress even tried to defund DAPA. But guess what? This is like Keith Richards. It cannot be killed. This will go on forever. It is paid for by user fees. The people applying for DAPA pay for it. Even if Congress shut down Homeland Security, people upstairs going, woo, right? Even if they shut down Homeland Security, this thing would keep going on. The only way that this could have been stopped was through Texas's lawsuit. Texas brought a challenge saying, listen, as states, we are injured, right? This policy injures us. How? Because we now have to grant driver's license to these aliens. And, well, we have to pay money out of the state coffers. It's a small amount, but it's countable. You can count the amount of money. And because of that, they're standing. Were it not for Texas's lawsuit, this could have never been challenged. I think the fact that the president announced this 2 weeks after the election to save his vulnerable Democrats is even more odious. So at bottom, we have an egregious violation of separation of powers. I'm glad it was checked. So let's actually talk about the Supreme Court's decision here. Nothing. It was affirmed by an equally divided margin. We had 4 votes on one side, 4 on the other. The justices don't say who is who, but I think we can guess. The 4 conservatives, or the 3, I don't know, Roberts and Kennedy, I don't know what the hell they are. But Alito, Thomas, Kennedy, and Roberts are disturbed by this. They seem very, very upset. Justices Ginsburg, Sotomayor, Kagan, and Breyer, they're not bothered by it at all. So what happens? It affirms 4-4. What happens next? So what we would have thought would happen was the case would have been remanded to the district court down in Brownsville, which this all began. I was actually in Brownsville a few weeks ago for a hearing. Not so fast. The Obama Justice Department filed what's known as a motion for reconsideration. Was a motion for reconsideration, asking the court, hey, can you guys take a look again when you get Merrick Garland on there? Pretty much. So the case is actually still pending at the Supreme Court. There's not been a mandate back to the lower court. So in the event that we have Judge Garland confirmed, the court can say, okay, we'll grant you reconsideration. Don't worry about anything else. We'll hear this again in January and give Hillary Clinton our blessings. The alternative, if President Trump wins and who the hell knows he picks, the case can go a different direction. But,
And what if a Republican wins?
good point. Are we counting Gary Johnson? What's worth Aleppo? I don't know where I am. So, shoot me. This is an awful year, my friends, awful year. Let's look back to the time when Scalia was still here. So in summation, this case can go a lot of different directions, and I fear and I expect that they will never actually address the take care clause in its entirety. But we should be very careful about the role between non-enforcement and gridlock. And let me explain what I mean by that. This is actually a preview of my piece coming in the Harvard Law Review in a few months. When Congress refuses to change the law, it's very tempting for the president to say, okay, you know what, I'm simply not going to enforce this law. I'm not going to enforce it. I got discretion, I have all these bills and resources, let's not enforce it. This makes Congress irrelevant. You cannot defund non-enforcement. When the president is not doing something, Congress can't stop him. And this is why I think you'll see more and more litigation to bring these sorts of disputes into the forefront. Another one pending is the House of Representatives lawsuit concerning illegal payments being made under Obamacare. This problem is endemic, and regardless of whether whoever wins, Republican, Democrat, fascist, whatever, whoever wins, the Supreme Court will have to confront this again. They punted here, but I suspect at some point they'll have to address the question square on. Thank you all so much for your attention. I look forward to your questions. Thank you.
Next, we'll hear from Hans von Spakovsky, who is